Good morning, everybody. We are missing a few people,
I think this is
but in the interest of respecting everyone's time, including our wonderful panelists, we're going to go ahead and get started. My name is Jan Brito. I am the CEO of Capital Senior Solutions, which is a division of Brito Associates of Compass. My business partner is Laura Quigley, who welcomed you when you came into the room, and then Jesse is our assistant. We are realtors who list homes, of course, but the whole purpose of these educational seminars that we do is to educate and advocate for older adults. So that is our passion in serving older adults. So we provide seminars on various topics every month. Today, of course, is probate for property owners. And just briefly, what qualifies Laura and I to even do what we do is we spent a year taking a very rigorous course, an advanced course in serving older adults. There are many designations realtors can get, but this one we felt was really special because it focused on all of the aspects of aging, not just selling a home for an older person. So we also have a senior downsizing club. There's a flyer on the table about that. And that's for people who might be, 1 to 5 years away from making a move or even making any kind of decision whether to age in place or move to a retirement community. Just a small support group. Howard's a member. We just casually sit around a table and share resources and talk about challenges. We might give you homework and things like that. But that's who we are. So today we're going to talk about probate for property owners. Most of us want to control our own lives. Is that an accurate statement? Yes. In fact, as a real estate agent, I recently went on an appointment to list a home for someone who had been attending our seminars earlier this year. I often ask the question, why did you ask me to come today? And on that day, here's what she said. She said, I have made a decision about where I am going to live because I want to be in control of my life and not have others decide for me. She went on to say that she specifically called us because she did not want to burden her grown children who all have jobs or live out of the area, and she had heard that we could help her with everything she needed for the move and sale of her home. The emphasis in this conversation with her was on two things: control over her decisions and not being a burden on her children. This seems to be a common sentiment as we talk with people. On the other hand, there's a paradox here. While people want to remain in control and not burden their children when they are living, it's often as if they no longer consider these things for after they die. In fact, many leave this life with absolutely no instructions or organization whatsoever, making it someone else's responsibility to decide how to handle the remainder of their estate. As a result, they have essentially lost control and definitely burdened someone else in the process. But there is something I have learned. It's not because people intend this outcome. It's often because they lack the knowledge about how to go about remaining in control and relieving the burden from others, or they lack the resources for doing so. So kudos to you for being here today and making the decision to be informed so you can remain in control of your estate even after your physical body isn't here. So I'd like for you to listen with two sets of ears today. One set of ears might listen in consideration of your own estate as we discuss the topic. What you might need to do, verify, or modify so that your estate is in good order in preparation for your physical departure. The other set of ears may make note the process and requirements involved should you become the executor of someone else's estate sometime in your future. So now turn to your neighbor and tell them you are most definitely going to learn something today. Now turn back to them and say, and it's about time. Okay, so I'll now turn it over to our wonderful panelists, Wendy Moyer and Susie Eckstein, and I'll let them introduce themselves, and then we have a series of topics we're going to go through, and you can throw out questions whenever they come up, and it's meant to be an interactive discussion, and I hope you all enjoy it.
My name is Wendy Moyers, and I am a financial planner and financial advisor with Chevy Chase Trust. And my experience in dealing with probate is on the financial side. I will let Susie talk about all the legal stuff and stay in my financial lane, but I help clients, once they have an estate plan in place, I help them implement it, and also I help their heirs distribute their estate once a client passes away.
Okay, I'm Susie Eckstein, and I'm an attorney who practices in DC and Maryland. We also have someone in our firm who practices in Virginia. So I've been assisting clients with estate planning and probate for 30 plus years. I focus on helping with all aspects of both processes, including the family relationships that need to be navigated during both processes. And our firm works together with our clients' financial planners in order to make sure that you get, all the support that you need through both processes. So do you want me to take the first one?
Sure.
I mean, you'll add
Yeah,
on,
yeah.
but so Jan asked us a series of questions to sort of think about and share with you all, and you can certainly raise your hand at any time to ask a question. So she wanted us to start by explaining what probate is and why it exists as a process. So probate is the process of the Register of Wills overseeing and assisting with the gathering of assets when somebody has passed, payment of the debts and administrative expenses, and distribution of the assets. And it really is used so that for anything that's titled in the sole name of the person who passed, to be able to get authority in order to access those assets and handle the debts in order to take care of things. And also it allows creditors to file their claims and prove their claims to whoever's appointed as personal representative so that they can get paid. But most importantly, from my aspect, is that the estate gets a release then for that debt.
So once we have that release, then my job is to come in and make sure that whatever assets that are under our management can be distributed appropriately to the heirs.
Okay. I mean, so you want to start with the next one, or you can throw it to me anytime.
I'll throw it to you.
Okay.
I think these first few questions are more in the legal lane, so
Okay.
I'm happy to let you talk.
So the question was, when is probate required and when it might be avoidable? So probate is not required in Maryland or DC. However, as I said, if assets have an individual has assets in their sole name, then in order to get those assets transferred, you will have to engage in a probate process. Unless you avoid it. I don't like to use the word avoid.
Say that again. I'm sorry.
So probate is not required in Maryland or DC unless you have assets that are in the sole name, titled in the sole name of the person who passed away, and then you will need to go through probate in order to transfer those assets. So there are ways to have assets pass outside of probate. I don't usually use the word avoid, especially in Maryland. And I used to say that about DC, but I have a footnote about that at the current time with what's going on there. But in Maryland, and it used to be in DC, and probably will be again shortly, it's really not something to be avoided necessarily. If you have not a complicated estate in general, it's a pretty easy process in both places, and it's not that expensive. There are ways, however, to have assets pass outside of probate, and if you can do that and it makes sense for your plan, then that's probably something you should consider. And those are things like beneficiary designations on retirement and life insurance, transfer on death or payable on death designations on investment and bank accounts, transfer on death deeds, although currently that's not available in Maryland, although there was legislation that was introduced last year and probably will be introduced again this year. There are some drawbacks to that, but we don't really have time to go into the details of that, or creating a revocable trust. Anything you want to add?
Yeah, and I think even though probate is not necessarily an onerous or expensive process, having seen what happens on the financial side, it can be helpful to your heirs to have other things in place besides the probate process. For example, I have the beneficiary of a trust that we help manage. When the beneficiary passed away, all trust distributions had to stop. And then she didn't have any kind of will or anything in place, so her assets are going through probate and her children have no way to access the bank accounts to be able to pay for her funeral. So they're kind of stuck. So not, again, probate doesn't have to be onerous or expensive, but does place some roadblocks on your heirs if you don't have a proper estate plan in place.
Are there any assets that you can't do a payable on death or transfer on death or beneficiary designation? So there are real property generally is not something that you can put a beneficiary designation on, although there are ways, for instance, in DC, they do have that transfer on death deed that I mentioned just a minute ago. You can also do a life estate deed. In Maryland, the transfer on death deed is not available yet. It really, if you're thinking about doing that, it may seem easier in the moment to do that, but you really should discuss it with an estate planning attorney because it has a lot of downsides. And it really depends on your particular situation.
What are some of those downsides?
Well, it's not as easy to change a transfer on death deed as it is, to change a trust, amend a trust, or take care of do a will, redo a will, or add a codicil to a will. You also don't have all the details of how that might work, especially if you have like a life estate deed, how that might work, who's going to pay what. I will say that I recently had a client who wanted their daughter who lives in a house they bought in California to be able to continue to live in that house, but she really couldn't afford it. So they did this transfer on death deed, but it would have been a disaster if that's the way it had happened. And really the other children were a little upset that that child was going to get the entire house. And there are so many different ways you can handle that to make sure it works for everybody in the family and that the property doesn't get lost because the person who got it, can't afford it.
What is a life estate deed?
A life estate deed is when you give a deed, so you're the owner of the property, and you keep a life estate, meaning you get to live there for your life. Sometimes you have the right to sell it, sometimes not. Sometimes you have the right to rent it, sometimes not. And then upon your death, it automatically goes to the person that you name in the deed. However, that can cause problems for the person who remains on the deed because there are tax consequences also that can be avoided in using a revocable trust. Whenever you're giving something to a charity, I would say that you really need to speak with the charity about how that would work for them and what they need, have them review any documents related to that so that, again, there's not problems at your death with how that will get managed. No, that's what we're here for. We'll I'm sure you're asking things that we're going to talk about. So yeah, we'll just skip over that when we get to it. Okay, so just some of the reasons that you might want to think about doing a revocable trust or avoid having things pass outside of probate by using a trust. There may be three sort of main reasons that I usually think about, although there are other reasons. One is privacy. So if you have just a will, then your will gets filed with the Register of Wills when you pass. Everything that you own is detailed in that filing and how it's distributed, and that is public information. With a trust, it remains private. So most of my clients say, I'll be dead, I really don't care. Privacy is just not that important to them. It is important when they have somebody in their family or somebody else who might cause trouble if they knew how much they owned and how they were going to distribute it. So that's something to think about. If they own property in more than one state, then you would have to probate in both of those states, which really in general is not a problem if the states are easy to probate in, but states like Virginia, which really are quite difficult from my understanding, you don't want to have to deal with that. So you can put both of those properties in the trust. Want to add to that?
I think, and I know the purpose of our conversation today is around probate, but one other thing that I like about a trust is for incapacitation purposes. So if somebody becomes incapacitated, on the financial side, it is easier to switch trustees than it is to come in as a power of attorney. Now, Maryland has, and Susie can speak to this, but Maryland has a fairly straightforward power of attorney, but again, it is a little bit easier, and also you can provide a lot more detail in a revocable trust about how you want your assets to be managed. It's basically an instruction manual for the person who takes over for you if you become incapacitated, how to handle the assets, how to pay the bills, what gifts to make. And so a revocable trust has a lot of good purposes, not just to go outside of the probate process, but also if someone becomes incapacitated.
Also, if you live in a state where probate is cumbersome or expensive, then you obviously want to try and find a way to avoid it. I will just tell you a little, DC right now is just a mess because they just implemented a new software program and electronic filing on top of that, and they're down about 50% of their employees. And so I just attended an informational session recently, and they said, they're really struggling right now to understand the software program and electronic filing, and by, the fact that they're down so many people. Before all this happened, even, during COVID, after everybody sort of got started learning how to deal with it, they were doing great. But right now it's a little bit of a mess and taking a long time. So that really depends on what details, it's the same thing as creating a will, what details you want in that trust. And I would say prices vary all over the place. Some attorneys, like our firm, do it on a flat fee, which we quote after we do an initial consultation with the client to see what it is that they need. We don't charge for that initial consultation, so nobody loses anything by giving us the information and trying to figure that out. And some attorneys do it on an hourly basis and require you to give them some kind of retainer that they bill against. So it really varies widely. But with us, we try and give people the opportunity to talk to us, and then we quote them a fee, and you can say, forget it, I'm not going to use you, or go forward with us.
Will you be giving out a business card?
If I had brought them.
You have the contact information on the slide.
Yeah.
Straight, you can see it.
Yes, sorry. I don't go very many places these days, and I don't think about that. But yeah, you can write it down from there or get it from Jan.
Share it with all the attendees via email afterwards.
Okay, there you go. Great. Thanks, Jan. Anything else you want to add to that one, Wendy? Okay. So probably the next one I will take is employing an attorney required to complete the probate process. So no, absolutely not. So when people come to us to ask about what it costs and what does it look like using an attorney for that process, really we can help as much or as little as that particular client wants. Usually the client is the personal representative that's been appointed under the estate. So many, I won't say most, but many of the people who choose to do it themselves end up coming to us partway through the process. And that's just because this is not something that they've trained for, or they really would have to learn and educate themselves. And most people have very busy lives and don't really have the time to educate themselves. It's not that it's so difficult depending on the circumstances, if it's not a complicated state. And the Maryland Register of Wills is wonderful at answering questions. But it's just that this is not something that they're educated in. And so they decide, well, the money to pay the attorneys coming out of the estate. So it just makes sense to not be totally stressed out about it and just let somebody else handle it who knows what they're doing.
On the financial side, I definitely recommend clients engage with an attorney for an estate process or estate administration. It's great to have a professional resource. You don't want to make a mistake.
Okay, so the
So
next,
you're saying that
yes.
the executor should hire an attorney?
Yes.
Yeah, and just on that note about executor, because a lot of people, when I say personal representative, they used to be called, and still are in a few states, executors. But in Maryland and DC and Virginia, they're called the personal representative. But it's the same duties, but people get confused by that. So since you mentioned it, Okay, so the next one is what's the actual step-by-step process of probate? So I'm just going to give you a general overview. Obviously, there may be issues within each step of this, and maybe Wendy can point out some of the, from the financial side of it. But in general, the first step is you file a petition with the probate court, and you do that so you can get your letters of administration as a personal representative. The letters of administration are just a piece of paper saying letter of administration, and it gives the personal representative authority to deal with the assets and the debts and anything to do with the estate. Otherwise, you wouldn't have the authority to do that. You don't have the authority simply by being named in a will.
And we wouldn't take instructions without without these court documents. You couldn't come and say, I'm the personal representative, here's the will. We would say, we can't do anything under your instruction until we have these papers.
So the second step would be to use your letters of administration to gather the assets. And then you would open an estate account and you would put the assets into that estate account. And Wendy might be able to speak to sort of what happens on her side of things when you come to her to open an estate account.
So you had to have a new EIN, identification number with the IRS, and we had to open up a new account and move all the assets over. So it is a little bit cumbersome to do that. And depending on who the personal representative is, it can be very difficult and emotional, especially if you're the surviving spouse or a grieving child. So it's a lot. It can be a lot, but whenever someone passes away, it's a lot, and there is paperwork. And some people find it to be helpful because they have tasks they have to do, and it helps them move through the initial grief process. But for a lot of people, it can be difficult. So, the more you know either yourself, if you're going to be appointed as personal representative, or your people that you will appoint as personal representative, the more you know them and what you can do to help them get through that process is useful.
So the next thing you would do is pay the debts and costs of administration of the estate. I will talk a little bit more about this later, but the best thing you can do for your family is to make sure you have everything organized, and I'll talk about the tools that can be used to do that so that they don't have to go searching all over your house through all your emails to figure out what debts there might be.
And we're happy, we can get it to you.
And we can
I've
send
got your
it.
email, I'll send it to you.
Yes, sorry. I don't go very many places these days. I don't think about that. But yeah, you can write it down from there.
Yeah, we could share it with all the attendees via email afterwards.
Okay, there you go. Great. Thanks, Jen. Anything else you want to add to that one? Okay, so probably the next one I will take is employing an attorney required to complete the probate process? So, no, absolutely not. So when people come to us to ask about what it costs and what does it look like using an attorney for that process, really we can help as much or as little as that particular client wants. Usually the client is the personal representative that's been appointed under the estate. So many of the people who choose to do it themselves end up coming to us partly through the process. And that's just because this is not something that they train for, or they really would have to learn and educate themselves. And most people are in busy lives and don't really have the time to educate themselves. Not that it's so compulsory in America that it's not a competition game, and those wonderful answering questions. But it's just that this is not something that they're educated in. And so they decide, well, the money to pay the attorneys coming out of the estate, so it just makes sense to not be totally stressed out about it and just let somebody else handle it because
on the financial side, I definitely recommend clients engage with an attorney for an estate process or estate administration. It's great to have a professional resource. You don't want to make a mistake.
Okay, so
note about executor, because a lot of people, when I say personal representative, they used to be called, and still are in a few states, executors. But in Maryland and DC and Virginia, they're called the personal representative, but it's the same duties, and people get confused by that, so since you mentioned it. Okay, so the next one is what's the actual step-by-step process of probate. So I'm just going to give you a general overview. Obviously, there may be issues within each step of this, and maybe when you can bring out some of the, from the financial side of it. But in general, the first step is you file a petition with the probate court, and you do that so you can get your letters of administration as a personal representative. The letters of administration are just a piece of paper saying letter of administration, and it gives the personal representative authority to deal with the assets and the debts and anything to do with the estate. Otherwise, you wouldn't have the authority to do that. You don't have the authority simply by being named in a will.
As we wouldn't take instructions without these court documents. We couldn't come and say, I'm the personal representative, here's the will. We would say, we can't do anything under your instruction until we have these papers.
So the second step would be to use your letters of administration to gather the assets. And then you would open an estate account, and you would put the assets into that estate account. And Wendy might be able to speak to sort of what happens on her side of things when you come to her to open the estate account.
So you have to have a new EIN identification number with the IRS, and we had to open up a new account and move all the assets over. So it is a little bit cumbersome to do that, and it's depending on who the personal representative is. It can be very difficult and emotional, especially if you're the surviving spouse or a grieving child. So it's a lot. It can be a lot, but whenever someone passes away, it's a lot, and there is paperwork. And some people find it to be helpful because they have tasks they have to do, and it helps them move through the initial grief process. But for a lot of people, it can be difficult. So, the more you know either yourself, if you're going to be appointed as a personal representative, or your people that you will appoint as personal representative, the more you know them and what you can do to help them get through that process is useful.
So the next thing you would do is pay the debts and costs of administration of the estate. I will talk a little bit more about this later, but the best thing you can do for your family is to make sure you have everything organized, and I'll talk about the tools that can be used to do that, so that they don't have to go searching all over your house through all your emails to figure out what debts there might be. The other thing that's important, and when you go to a financial institution, is when you open the accounts, make sure it has a
Writing function so that you have the ability to be able to write checks for the debts, et cetera, from the estate. Is there anything about that, Wendy, that?
Well, for example, with our type of accounts, they're investment accounts, so we don't actually have check writing capability, but we can write checks for you and make distributions, electronic distributions. So there are ways to make distributions without check writing, but I think that's important to know about for a bank account for sure.
Yeah, so oftentimes, especially if you have a significant amount of assets, we'll open an account with an investment firm, although we have to sort of make sure it's an account that's not going to lose money. The personal representative's job is to maintain the assets also. So you don't want to put it in an investment account that's going to go up or down, like they have been going sort of in the past year or so, although now they're starting to go up some. So you got to be careful about that. But then you also, if it's going to be a lot of checks that have to be written, like to maintain a house, going forward, you might want to also open a bank account, and then you can transfer money from the investment account into the bank account.
Yeah, that's good.
Okay. So the next thing you would do is, once you're done with gathering all the assets and paying the debts and costs of administration, is you do a full accounting of all the work that you have done. have my clients send me the information as they go along and do it so that we can put it into the accounting. So when they're done, it's actually already prepared and we can sort of catch if there are problems as we go along. And so you really need to do a full accounting of everything that came into the estate, everything that went out, things that came in after the initial sort of accounting of assets. And then finally, you would, after court approval, you distribute the accounting, you distribute the assets to the appropriate individuals. So questions about any of that?
If there's no drama or anything, how long does it take for all of this process to happen?
So, it used to be that people are like, oh, I don't want to do probate because it takes forever. I don't know about DC at the moment. It will take a little longer, but in Maryland, you can do it fairly quickly. I mean, certainly as quickly, I always say a revocable trust. I think revocable trusts are great. I'm not saying, I do revocable trust for my clients, but really you need to follow the same process as far as time is concerned if you're the trustee of a revocable trust or if you're the personal representative of a will. So generally speaking, you want to leave money in the account for 6 months so that creditors, that's the time period that they have to file claims. So you want to make sure you don't get claims after you distribute it, because as the personal representative, you're responsible. And so it can be done really quickly. In Maryland, you can get a probate petition filed, and a few days later, you have the letters of administration. You start gathering everything. If you have a house that needs to be put on the market, there are many things that have to be done, all of which I have to say, I always use Jan because she helps with all of them, including the packing up and getting things sold and just figuring out maybe if there was somebody still living in the house, where that person's gonna live. There's so much involved. And so it's so helpful to have somebody who knows what they're doing. So the time period it takes to do that, and then, getting it sold and having the settlement date and getting all the debts paid and taxes done and things that have to happen. And you really, by the time you're done with all of that, you can close the estate in Maryland. You used to be able to do that in DC, but it's going to take a little longer just to get it open to initially. So actually, there are lots of things that could delay that process, and I would say the number one thing that delays it is when people don't organize their assets ahead of time or before they pass, so that the person coming in can, easily know what they need to take care of. So I had a client who passed away. There was a delay because there was some disagreement from the court about how the documents were drafted, of which I did not draft them, P.S. But I was representing the personal representative. And the woman who passed she must have had 30 different accounts, like 10 CD accounts, 10 savings accounts, and the person who was the personal representative was a close friend, not really family, but a close friend, knew her pretty well, visited her all the time, but he lived in another state. And all the papers were just in her house, and there were papers everywhere. And the computers, there was 4 computers. They were all older computers. Fortunately, the personal representative was a computer guru, so he was able to access some of the stuff. But it just took forever to go through everything. We actually hired somebody to go through a lot of the paperwork to get rid of the stuff that wasn't important, but we didn't know what was important. So we had to make sure we went through it all. That is the biggest nightmare for families and or friends who are sort of left behind to deal with things. And so the biggest gift you can give is to have that stuff organized. Really, as a couple, if you're part of a couple, for each other, because usually one person deals with that and the other person doesn't really know what's going on. That's, in any couple, even if you both work and, are out in the world, and for, so for each other and for your children, or your adult children, or whoever you leave behind.
Susie, do you recommend a certain resource or guide that people could use to do that? In my family, we call it our disaster book. And my husband took years of kind of created his own little path. And I don't know if he captured everything, but are there resources out there readily available?
So Wendy, I have some tools, but you want to
Go ahead.
Okay, so we give our clients two main tools, but there is so much about this on the internet. But what we do is we give our clients a template for a letter of instruction. And that really what that is an outline of everything that somebody would need in order to, figure out what needs to be done if something happened to you temporarily or permanently. The other resource is just this article. I used to read the Washington Post from cover to cover, especially the business section, and they had a real estate, in the business section, they had a guy who answered questions about real estate. But there was so I just used to read that. But the Washington Post article that we have, which we give to clients, gives you a roadmap for what documents you should gather and keep together with your letter of instruction and with your estate planning documents. So I will say the number one thing which amazes me when people come to me, they often say, well, we did these documents years ago, but we have no idea where they are. So that is really important. So you put all this stuff together and you want to make sure that you put it in a place that you're going to remember, and that you want to let the people in your family know that you've done the documents and where they are. It is hard sometimes to talk to, especially adult children, about these issues. But that's my number one advice, besides getting everything together, maybe that's my number two advice. Once you've done that, talk to your family. If you have adult children that are sort of younger, like mine were when I first talked to them in their 20s, they might be like, you're fine, I don't need to know. And I'm like, okay, you're not ready for this. I'll tell you more when you're ready. But I want you to know the documents are in the drawer, in the upstairs bedroom, and here's the main person to contact if something should happen to us. Of course, now they're the main person to contact, so we've told them that. We switched it to put them, and anytime they want to know a little bit more, but really everything they need to know is in that drawer.
And I want to echo where Susie has put that, because a lot of people take their information and put it, for example, in their safe deposit box, which you can't get to. So you need to make sure that you share the information with the people that need to know, and then make it easily accessible so they can get at it when they need to get at it.
So just talking about some of the other challenges, those would be the top two challenges. A challenge that I've encountered in my career, and one that I'm dealing with right now with a family, and deal with this quite often, is when parents add their children to their accounts. So they're joint account holders. And really what they want to do is just give that person control of the money to give to everybody else. So there are 5 siblings in this family that I'm thinking of, and the one daughter got everything. She got the $1 million retirement account. She got the $500,000 investment account. She was on all the bank accounts, and now her task is to find a way to distribute. The will says everything should be distributed equally, but all of these things passed outside of the probate process. So there is nothing to be probated. It's just these assets. And now there are all sorts of tax consequences for my client, the personal representative, who really, none of this has to do with the personal representative. We're working with the accountant to sort of figure out the balance sheet and how she can distribute it, because she wants to distribute it. But under the law, it's her property. If you have a joint account with somebody, under the law, it goes to the person who survives. And if you have named your daughter as a beneficiary of your retirement account, but you want to distribute it to everybody else, the one daughter has all the tax consequences. So you shouldn't do that. If there is a small joint bank account that you want to have available for the one person who's going to have to handle everything and pay the funeral expenses out of, and some small amount for that, and taking care of things until the estate can be opened, That's probably okay as long as everybody gets along and nobody's going to complain. But I just strongly encourage don't do that to your children or whoever you leave behind.
I think probably based on Susie and my experience in this, we could regale you with so many terrible stories about mistakes people made. And so I just want to reiterate that it's important to think about your plan. And I think people find it very daunting to like gather all this information and bring it together. And that's where Susie and I can come in and help you with that process and think about these things need to be listed. But I also want to reiterate that as daunting as it is for you and you live it and you know it, it'll be even more daunting for the person who, if it's your spouse who doesn't really follow along with the finances, or your kids or a friend, it's daunting for you, it's even more daunting for them. So.
Another challenge that kind of comes out of not sharing sort of what you did in your estate documents, not just what you own and where you can find it, but what the plan is that disputes arise, especially when heirs are surprised at how you did things. So I have a client who I just spoke with recently who has one daughter who lives with her and wants to give that daughter the house, and then she thought about it and said, well, and the daughter really actually doesn't want the house. What she wants is to be able to live there for a period of time until her children graduate high school, since they go to school, in that school district. And the one piece of advice I gave her was to really talk to, if that's what you're going to do, if you're going to let that one daughter live there, then you really need to share that information with the other siblings so that they know the plan. And that they're not necessarily on board with the plan, but you're less likely to have a dispute that ends up in litigation, which litigation in this area has probably quadrupled over the past 20 years. It's just more and more. And I find that the best way to avoid that, and the families that don't have those problems, are the ones that share their plan, even if it's not a plan that everybody's on board with.
100% agree. It's uncomfortable to talk about these things with your heirs or the people who are in charge of your estate, but it will be so much better. People may have in the back of their minds, like especially in families where the mother is the glue or the father is the glue that keeps all the siblings together or the kids together, when that person passes away, wars break out. So even if it's an uncomfortable situation, even if not everyone agrees, it is better to talk about it. And if you all get along and everything is good, it's still better to talk about it so there are no surprises. The surprise factor after the fact is very difficult for people.
And so what I would say is that probate is not just a legal and financial process. It is a legal, financial, and emotional process. And that's one of the biggest parts that we help our clients navigate. And estate planning itself can be an emotional process. I have couples all the time that I have come to me and they have different perspectives. I mean, we all have, different perspectives on how things should be managed. And so we try and help people in the estate planning process navigate those conversations comfortably and come to a conclusion that everybody can feel comfortable with. That's just a big part of both the estate planning and the probate process, is the emotional component and thinking about the family members. Sometimes we meet together with the parents, if the parents want, and their adult children to sort of describe, here's what the plan is. Does anybody have any questions? Again, not so they can say, I don't want you to do that, and there'll be a change made, although the parents may be interested in hearing what their kids have to say, but just to help them navigate those conversations, whether they're difficult or not difficult conversations. And then you avoid those problems later on. Yes?
If you have a trust, do you move your assets into the trust while you're still living?
Yes, so generally, you'll hear them referred to as revocable trust, living trust, revocable living trust. So whatever you want to pass through the trust, you definitely want to put, I mean, the idea is to put most of your assets in the trust. There are certain assets, and Wendy could probably talk a little bit more about this, that you don't want to put in the trust, like retirement. So I'll let Wendy.
Yeah.
I'm going to speak to that.
So once Susie drafts your revocable trust, then you bring that to your financial person and we help implement that. And we want to follow the instructions very carefully. But let's say you have a regular brokerage account, we'll retitle it into the name of your trust. But as Susie said, for retirement accounts, they are in a person's name and can't be changed from that person's name. So that's where the beneficiary designation comes into play. And your attorney will advise whether your beneficiary designations should name a person or name your trust, and we'll follow those instructions. But the financial person, it is important to have your financial person involved so you don't have this amazing plan that never gets implemented. So that is an important question and an important step to follow once the plan is in place.
So if you move your assets into a trust, do you have to file 2 tax returns?
No, it's one, it just goes on your personal return. It's the same, the tax ID number is your social security number, and you can deal with your money the same way you could deal with it if you were, had it in the individual. I want to say that what Wendy's saying is, yeah, it is important to make sure that you take that extra step. I do find people who have done trust years ago come to me and they haven't put anything in the trust, and that makes things so much more complicated. What we try and do is work together with the financial planner for our client to make sure that everything's covered. So after I meet with my clients and we're in the process of drafting the documents, before I finish drafting and before they sign, I meet with my client's financial planner to get the information, make sure I have it. Lots of times they have information about my client that I wouldn't know. For instance, I had a client who had a daughter who really had special needs. She wasn't on any kind of assistance yet. She was living at home, but she probably would be. And my clients didn't share that with me, even though I do ask questions to try and get at all of those information. But the financial planner had been working with the client for 20 years. I just met the client, 2 months ago. So I think it's really important. They oftentimes have been working with the client a lot longer and have information. So I always ask for their input. Sometimes they have input. Sometimes they're like, no, that sounds good. And also to just get the details and make sure who the beneficiaries are, and that after my clients sign their document, we have a specific meeting together with my clients to make sure that they've gone through with their financial planner and made all the changes that need to be made, and if they have any questions. And there may be phone calls that I have with the financial planner in order to make sure that's all done. Yeah. I think we might have gone through
All the questions.
most of the
yeah.
questions that Jan had told us. I don't actually have any idea what time it is.
Well, actually, we're doing perfect. It's 11:47.
Okay.
We do these as 1-hour seminars. We always allow a little extra time for Q&A and to run over and so forth. But I know questions have been asked as we've gone along, but if you have any others, please feel free to speak up. One thing that came to mind for me as I was listening to this conversation is there's a lot of communication that has to go on here, right? Not only with your professional advisors, but among your family members. And sometimes those can be a little difficult. Let's face it. And I wanted to talk about 2 seminars we actually offer that help you to deal with that. Was it last month we did Communicating with Adult Children, which was really, really great. And we have another one not until November, unfortunately. But you can go to our website, capitalseniorsolutions.com, to the seminars page, and there is a recording of that. So you can watch that if you don't want to wait till November. And another really good seminar we have coming up is called Moving Mom and Dad. Now that is geared towards adult children, which many of you may have, and you might want to recommend that they consider attending, and perhaps you'd like to as well. We have one in January at the Ring House in Rockville, and then one here in April, back here at Lakewood. So,
And I just want to add the Moving Mom and Dad. Yes, that's ideally for family members and adult children to come and hear that process. But I really think it's important for the people who are going to be doing the moving to be there too, because that will facilitate the conversations that you need to have with your support team through the process.
All right, so we have a list of upcoming seminars there on the table for you, also some information about our Downsizers Club. And I want to thank immensely Susie and Wendy for your knowledge and all the information you shared today. Weren't they terrific? Did you get some good information today?
Yes.
Great. Thank you so much.
Are there any questions? Anybody have
Any
any
other
questions that we
questions
didn't
from
get
anyone?
answered?
So I can repeat the question. It's in the case of a couple and everything is in joint names, the accounts, et cetera, what needs to be done when one of them passes? So maybe nothing except for under the law, you're supposed to file the will with the Register of Wills. You don't need to go through a probate process, but the law says that if there is a will, it should be filed. And then you have to fill out a form, which basically it gives answers to questions that allows the court, the Register of Wills, to understand that there's nobody that has to pay inheritance taxes, because Maryland is has both estate and inheritance taxes. One of only 2 states, by the way, that has both those things. So you have the privilege, if you live in Maryland, of living in that state. But yeah, so if it's passing to your spouse, there would be no inheritance taxes. So that wouldn't be an issue, but you're supposed to do that. Does everybody do that? No. Is there a problem with that? Generally, no. But certainly I would advise you to do it, because then you don't have to worry about any problems by not doing it. But everything in the bank accounts and joint brokerage accounts, as long as they're joint with what we call rights of survivorship, would pass to the other person. If the house is titled as husband and wife, in Maryland it's called tenants by the entireties, then it would go automatically to the other person. And you might want to use the death certificate to change the deed to take the other person's name off of the deed. So when you sell, it's a little smoother, but it also can be done when you sell it. So yeah. I think it's a good idea to have a conversation with a lawyer to make sure that everything is covered, but it's not, you know, I think it's good to have a conversation with an attorney to make sure you don't miss anything, but it's not necessary. I mean, you don't ever have to hire an attorney. I do want to add, because this was one thing I wanted to just sort of make a note about, is that it's really important, even in those situations, to have a will, regardless. You know, some people are like, oh, I don't need a will because everything's joint. Sometimes people forget, oh, they titled the car, or they had this one account that's not in both names. And what happens is, in Maryland, if you want, you would expect, if you don't have a will, what would you expect? Especially if you don't have children, you would expect that all the money would go to your spouse. That's not the case in Maryland. If you don't have children and you don't have a will, half of what you own goes to your spouse in your own name, and the other half goes to your parents. Now, nobody wants that. In general, most of the time, that's not the result that people want. So even if it's just, oh, I'm just leaving everything to my spouse, most of our stuff is in a joint name, you have to be careful about that and make sure you have a will.
And I would say more strongly, yes, talk to an attorney. I think it's a good idea. In Susie's example of a house being owned joint tenants, or joint by entirety, tenants by entirety. If there's some amount of time that occurs between one spouse passing away and the next, yes, you don't necessarily need to change the deed, but if a decent amount of time passes, it makes it more complicated. And again, I am not an attorney. Susie deals with this, but I have seen where it became more difficult and complicated for the person to sell the house. So I think it's good to just dot all the I's, cross all the T's, make sure you formally make changes and use a professional to help with that process, because it can get complicated and difficult if you don't do it correctly the first time around or right away.
Yeah, I think what I have seen is with COVID is time had passed, they lost the death certificate, and then trying to get a new one during that time period at the beginning of COVID was very difficult. So, Wendy's right. If you get it all done right away, then the things that we don't expect to happen in the world may not cause as much trouble.
I think there is a very good chance that there are some cats and dogs out there of random things that you forgot about. The car is probably one of the most common things, that if you don't have a will and you have a car in your own name, then like extra steps have to be taken. You can do you can do something with your car title, but most people don't think of that.
Car is worth so very little. It's a 1994 one.
Yeah, you wanna have the will. If there is that random thing that needs to be taken care of, then the problem is things have to be filed with the court. A bond has to be given to the personal representative. A bond has to be paid by the personal representative, because if you don't have a will that waives the bond, then a bond is required. There's so many things that can be avoided by doing a will and talking to an attorney about a will. I mean, certainly talking to our firm, we do an hour to an hour and 15-minute initial consultation about doing a will. If you decide at the end, after learning all of the things, after we get all the information from you, that you don't want to do one, that's fine, but at least take the time to, get the advice. But I would say everybody needs a will so that there's no problems for your family or friends that you leave behind. So, and there's no question about how you wanted things done.
Where is your office located?
So we're on Research Boulevard in Rockville, but we're going to be moving to Gaither Road, so 5 minutes. Gaither Road in Shady Grove, actually on December 29th. It's a little chaotic at my office right now packing. But so we'll be on Gaither Road as of...
Is that Rockville or Gaither?
It's Rockville. Yeah, it's the corner of Shady Grove and Gaither Road. It's at the back of where King Farm is. We do all of our, right now, unless clients, prefer to come in person, we offer doing our meetings by Zoom, so that the only time you have to come to our office is when you sign your documents. People are welcome to come in person, but we've just found that working by Zoom, people love it because they don't have to travel, and it makes it super easy. You had a question?
So you just mentioned a death certificate. So maybe these questions are inappropriate. Say you come home and your partner has fallen down the stairs and died, or your partner passed away in the hospital. What do you do then? You call the police? You call the funeral home? What are the steps even before this probate?
Yeah. I don't think you need to call the police. Probably calling a funeral home if your person is in the hospital for sure. That would be and they passed away. That would be the next step is to start making those arrangements and calling the funeral home, because the hospital will hold on for a short period of time to the person, but they want to release it to the funeral home as soon as possible. And the funeral home will provide the death certificates. Usually takes a couple weeks to get those.
I noticed you mentioned death certificates plural. How many should one obtain upon death of?
Depends on how many assets you have. If you have a lot of accounts, you'll want more, because every institution will want a copy of the death certificate. So that's just another reason to be more organized and consolidate your assets as much as possible, so you don't need to order more death certificates. And I don't think your question is inappropriate. I actually had a client in DC, and her husband passed away very unexpectedly. He wasn't sick. He passed away in his sleep. And it was in the middle of the night, and the police did come to make sure she didn't do something to him. And so it was 2 a.m, her spouse just passed away, and the cops were there. And they left very quickly. It was clear that she hadn't done anything, but if you're not in the hospital or under doctor's care, it is a legitimate question and something that happens. So,
And in case you were wondering, Wendy's office is in downtown Bethesda, and she does offer parking in the building.
I do. Yeah.
I have a question and a statement, I think. First of all, far as getting an attorney when someone passes, absolutely. I mean, my parents both passed when I was 29, and I could not have done it. Even though they had a will, they had all this stuff, it was just too complicated to have done it on my own, and I was younger. Now here I am, middle-aged, don't have a will. We've gotten to the point where we're going off and buying our cars on our own, so our cars are in our own names, and they're newer cars. So obviously I'm gonna have an issue with that. What happened with that? If my husband and I both have vehicles in our own names, they would not automatically pass to the other spouse?
If you don't have a will and you don't have children, it would have to be, if you have children, it would then pass to your children.
But it would not pass to this other spouse?
It would, yes, it would pass, well, actually, a portion would pass to the spouse and a portion would pass to the children. So it would have to be sold. I guess my, sort of figure out what you want, have that conversation with an attorney about, what happens if I don't have that will, this is what I want. Will that happen? To make sure that your result, and check in with that attorney every year if you don't do that will, or even if you do. We ask our clients to check in every year because, when we do estate planning for our clients, we ask them to check in yearly because the law has changed so rapidly in the last 10 to 15 years. You used to be able to set it and forget it. You can't. And so I say, call me every year, tell me what's happened in your life to see if we need to make changes. I'll tell you if there are any changes in the law. If we don't need to make any changes, then we've just caught up with each other. That's great. If we do, we'll figure out what needs to be done, how much that will cost, and if you want to do it at this point.
You would think by now I would have gotten a will.
Listen,
We used to go
yeah.
and write a note and leave it on the bed in case something happened to
Yeah.
both of us. Now the kids are all of age, but still.
Yeah,
it's like,
you would be,
yeah, Jessica, the lockbox is there, everything's in it.
you would
But
be,
I don't have a will.
Yeah.
you would be surprised how many people don't and don't think about it. But it's really an important gift, as Susie said, and it's not just the will. It's your financial power of attorney and your healthcare directives. If you become incapacitated, who do you want to make decisions for you? And you need to appoint someone. It's really important so that you can have these instructions laid out very clearly for the people who need to step in when you cannot. So the whole thing, it's not just the will, but it's other documents. There's 3 documents, and you really should keep those up to date.
And I actually would say there's 4 because sometimes the healthcare directives are put together, but there really are 2 pieces to that.
True.
There is what you want to happen if you're at the end of your life in one of 3 conditions, what kind of life-sustaining treatment you want, and then who you want to make decisions for your agent. If everybody thinks you're going to be okay, but maybe you're just unconscious and somebody has to decide surgery, medication, but that's a separate issue. So I like to separate the documents from what decisions you want at the end of your life. And if you do those documents, again, important to talk to people about what your choices were before you need to implement those documents before they need to, because, I've had clients where the children have ignored the end of life documents. The client, they've come to me afterwards and I know that it's just been ignored, and that the person who wanted maybe not to be kept on life support is kept on longer than they would have wanted. And there's a lot of strife in the family about what should have been done. Do we do a feeding tube? Do we not? These are hard things to talk about, but you don't want your family to be struggling with them when the event happens.
Mm-hmm.
I don't want to end on that note. And I was going to say that's the end note is that if you communicate about these things, it will, help everybody feel more comfortable, because people are, they have questions and they're afraid to ask. My parents' generation, it was, you asked and they wouldn't tell. That's what I've found with a lot of people of my parents' generation. And so I'm determined not to do that with my kids. Like, I'm going to tell whatever they need and whatever they ask. And it opens up a really good conversation. And then when events happen, it's much less stressful for them.
Agree.
And they get to feel heard. Because it's not just us telling them what we want. but it can be, two ways of them explaining or expressing their frustrations or what's important to them. And just quickly on my side, I just recently did this with a child and made it very clear what the plan was, and his reaction was so negative because that's not what he envisioned. And it led to a really good, robust conversation and a better plan for everyone. So,
Well, thank you again, everyone. If there aren't
Yes.
any further questions, we'll have a wonderful holiday season, and we hope to see you at another seminar soon. Thank you.
thank you guys.
And thank you again so much.